Good morning, Mr. Wood.
Good morning, Your Honor.
You may proceed.
My name is Chauncey Wood, and I represent the appellant, Kevin Montez. In this case, the District Attorney of Hampden County himself violated the defendant's right to a fair trial by using a series of collateral bad acts to make an improper propensity argument. Specifically, the prosecutor introduced 2 burglaries, an assault with intent to rape, and a case of indecent exposure, specifically masturbation, to support an argument that the defendant was, quote, a housebreaker, quote, a sexual deviant, and thus, quote, the type of person we're looking for in this case. There are 5 points here. Given, first, the fact that the collateral bad acts were not admissible for any legitimate purpose. Second, their highly prejudicial effect. Third, the fact that the prosecutor relied on them explicitly to make a prohibited propensity argument. Fourth, the fact that defense counsel objected both to their admission and to the prosecutor's reliance on them in closing argument. And finally, fifth, the evidence that another culprit may indeed have committed the crime here. The admission of the collateral bad acts, and the prosecutor's use of them in closing argument constituted prejudicial error.
Mr. Wood, didn't Judge Moriarty conclude that allowing in the evidence of these other acts was related to showing a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive?
Your Honor, well, first of all, he offered no justification for the masturbation at all. He didn't discuss the masturbation at all. He admitted the other 2 bad acts, that were 3 bad acts actually, the Frink and O'Brien break-ins and the Kelly assault on the issue of identity. That is the only, the Commonwealth offered the masturbation incident, the indecent exposure, on a theory of that it was relevant to motive, intent, and plan to procure sexual encounters. But Judge Moriarty did not rely on that.
So he relied on it to establish identity?
No. Well, the masturbation, he did not make any ruling at all as to why it was relevant. But with regard to the other 2 incidents, yes, he was.
All right. He
relied on identity, and he argued that it was relevant to identity, and I submit that was an abuse of discretion, that ruling. But I want to state at the outset that I submit that this case is very much like Commonwealth v. Triplett, another first-degree murder case before this court, which involved, likewise, the erroneous admission of collateral bad acts, likewise, over the defense counsel's objection, and likewise was an argument which was relied on by the prosecutor to support an improper propensity argument in closing argument. And for the same reason, this court should reverse the defendant's conviction here. Now, I want to address the Frink and O'Brien burglaries first. While there was some evidence that Mr. Montez committed these burglaries, there was no evidence that they shared a special mark or distinctiveness with the Andres homicide to warrant admission. Now, again, that's the relevant question here, the only question here, because Judge Moriarty introduced them on the issue of identity. Because they were introduced only on the issue of identity, and the only plausible argument made was that they were relevant to the issue of identity, the Commonwealth has to show that they share a special mark or distinctiveness with the Andres killing. Now, first of all, the method of entry, notwithstanding Judge Moriarty's argument and the appeals court's argument and the Commonwealth's argument, everyone seems to insist that the method of entry in these 2 break-ins and Andres' case was by key.
Yes, I wanted to ask you about that. You argue that in your supplemental brief that it wasn't by key.
That's exactly right. I'm saying that, and I also argue that in my main brief, but this is a fundamental factual misunderstanding, and I submit it's completely clear from the record. First of all, in both Frink and O'Brien, the individuals, the factual scenario is fairly similar. They both come home from a weekend away, and they find their front door is locked, a chain lock, from the inside. They've got their keys, and this is crucial. They have their keys. Their keys have not been stolen. There is a misunderstanding throughout this case that somehow they had lost their keys. Ms. Frink reported that her car key and her work key were stolen, and perhaps that's a result of some of the misunderstanding comes from that. But she did not lose her house keys. Likewise, Mr. O'Brien did not report losing his house keys. Nobody had lost their keys. But in any event, both of their doors were chained from the inside, the front door. Both people did the same thing. They went around to the back door. They found that they could not get in the back door. Now, there is some inference required here.
Why couldn't they get in the back door? You don't know.
Well, the argument I make here is, if we're talking about whether a key was used, if a key could be used to the record is not entirely clear here, but I think that the inferences are clear. If we're talking, the question is, could the entry have been made by a key? If the person could make entry by a key, then these owners or occupants could have gotten in the back door with their key. Neither of them
No, it could have been bolted from the inside.
Well, this is my point. My point is, if I agree with Your Honor, the evidence is almost clear, indisputably clear, that it was bolted from the inside, and as a result, they could not get in with their key. Recognizing or accepting, concluding that Your Honor is absolutely right, that it was bolted from the inside, and that the front door was chained from the inside, the inescapable conclusion is that the intruder did not use a key. That, in fact, the intruder broke in through a window and left through a window.
Why possibility that the person used the key to get in and then put the chain on and then went out of a window? Isn't that an option, too?
Well, first of all, I submit, as I said at the beginning, there's no evidence that either of these occupants had lost their key. Their keys had not been stolen. But the evidence is clear that Ms. Frink, in Ms. Frink's case at least, a window was open. And therefore, it is likely, almost inescapable, I submit, that the intruder, if the intruder could escape through a window, the intruder most likely gained entry through a window. But so when you combine that fact with the fact that neither of these occupants had reported having their keys stolen, then I submit that there is no reasonable conclusion that the intruder gained access with a key.
Was there any evidence in O'Brien's instance, any evidence at trial of how O'Brien, the entry was made in O'Brien?
His back door had glass panes on it, and one of the panes in that glass door was broken. So, and that was in the record, that's established in the record. I submit that indicates that in the O'Brien case, the most likely scenario is that the intruder somehow reached through in that opening, either climbed through that opening. There was no evidence about how big that opening was. So either climbed through the opening, or if it was too small, which is probably a fair inference because it's a back door, and it's probably smaller panes of glass, but again, there's no record evidence, that intruder reached through there and that opening and unsecured the lock, whatever that lock was, probably a deadbolt or a chain. But again, Mr. O'Brien did not lose his keys, so there was no evidence that, and the evidence contradicted this claim that a key was used. Second, and this is equally important, the nature of the crime. We're talking here again about the Brazgulis standard of special mark or distinctiveness, which this court said in Brazgulis is a very demanding standard. Okay, the nature of the crime. Again, both of these individuals were away at the time, and this was a break-in to an unoccupied apartment to steal property. That is clearly distinct from the case before us, a brutal murder, which was, in short, there was no violence in Frink and O'Brien. There wasn't even an individual present. In this case, in Andre's case, it appears that the individual broke in primarily to commit an act of violence. So what we have is two acts that are relevant at most for the question of whether the defendant broke into the apartment. But this is clearly simply propensity logic. Because he had broken into Frink and O'Brien, he's more likely to have broken into this apartment.
Again, back to Judge Moriarty's findings, he said, the four incidents of which the Commonwealth intends to offer evidence all occurred within a period of less than 3 months. You don't dispute that?
No.
They all occurred in the same neighborhood within short walking distance of each other.
Yes.
You don't dispute that. They all involved intrusions into residential apartments and multi-apartment buildings. You don't dispute
No.
that. And in all of them, there is at least a suspicion that the intruder had in some way obtained a key or keys with which to gain access to the apartment. You don't dispute that?
No, I do dispute the last one. I absolutely dispute that.
Well, wasn't there some question about some of the keys disappeared?
Not in this case. There was there was some evidence of that in Kelly, and there was some evidence of that in the Andres case. There was no evidence of that in Frink and O'Brien. And again, I think this is important. In Frink, her keys were stolen. The keys that were stolen, and this is clear from the record, were a work key and a car key. And I think that perhaps there was some confusion in the appeals court, perhaps, about that, that was the key. But that key had nothing to do with her apartment key. So I agree with your, well, I don't know, I don't want to.
I haven't finished.
Sure, go ahead.
So Judge Moriarty went on to say, most important of all is the fact that property stolen from all of the apartments, with the exception of the Kelly apartment, was found in the Montez Sotomayor apartment, and the bandana and gloves that Miss Kelly's assailant had worn and the knife that he had carried when he attacked her were all found there also.
Yes, I don't dispute that. Now, with regard,
Excuse me.
With regard to Frink and O'Brien, and I've made this clear in my briefs, and I don't dispute that there is evidence, perhaps at least by a preponderance, that Mr. Montez was the person who broke into Frink and O'Brien's apartments. I think it's certainly plausible that he was simply a fence, that in fact the person who broke in went to him to sell him the goods. But I recognize that because this property from Frink and O'Brien's apartments was found in his apartment, there's at least a reasonable basis to conclude that he was the one who broke into their apartments. But this is precisely the point of the propensity rule and specifically the Brazgulis rule, that there has to be a special mark or distinctiveness. I submit that the list Your Honor has presented, first of all, the fact that he was that the property was found in his apartment, and therefore you can infer that he was the one who did this, that does not have anything to do with the special mark or distinctiveness. That simply goes to the question of whether he did it. Then you get on to the next question, the crucial question, whether there's a special mark or distinctiveness. Now, with regard to that, the points that Your Honor has cited to that are helpful or relevant, I submit, are first, that this was a multi-unit apartment break-in. Second, temporal proximity. Third, geographic proximity. I submit that those factors alone are not adequate to establish a special mark or distinctiveness. What we're talking about here is M.O. And as Your Honors, probably Justice Spina, if no one else knows, this area, this neighborhood, every building in this area of Springfield is a multi-apartment unit building. So any crime committed in this area is going to be in a multi-apartment unit dwelling. But this is not, the fact that there's temporal and spatial proximity and the fact that it's in a similar kind of building is not a special mark of distinctiveness. I mean, goodness sakes, if somebody commits a break-in in one, and this is exactly what we have, a break-in for a property crime in one hand and a brutal murder on another hand, those obviously do not have a special mark of distinctiveness. There are characteristics that they share, but they do not come anywhere close to satisfying the Brazgulis standard. If there were evidence and I reject this notion that Judge Moriarty advanced and that has been advanced throughout this case at every level, that there is some evidence of a key being used to gain entry. I submit that the facts clearly contradict that with regard to Frink and O'Brien. Now, and then the last point on before I leave Frink and O'Brien, the prosecutor actually used, this is a recurring theme on all of these issues, how did the prosecutor actually use this evidence once he got it in? He used it blatantly as a propensity argument. He did not use it in any way to establish identity. This is what he argued, and it's the same argument with regard to every single incident. It's a three-step argument. Andre's killer was a housebreaker. That's his term. He broke into her house. Second, Frink and O'Brien breaks show that the defendant was a housebreaker. Third, therefore, the defendant was the Andre's killer. Of course, this is logical, but it's also
It's actually not logical.
Excuse me?
It is actually not logical. If you take in basic logic, A equals B, B equals C, it doesn't work. I mean,
Good. Well, then,
check it out with a statistician. and you'll
excellent.
find-
I was an
I mean,
English
it's-
major, not a philosophy major or a statistician, but I will accept that help. In any event,
It's not
it is.
help, it's just saying it's not logical. I mean,
Thank
it
you.
may be something else. It may be probative, it may be relevant, it may be anything else. It's not logical.
Okay. In any event, it's clearly propensity. It's clearly a propensity argument, and that is clearly explicitly prohibited. Now, moving on to the
Well, I have a question on another issue. Why was the evidence of the victim's intoxication relevant at all? There are a lot of arguments about how intoxicated she was, but why did it matter?
Okay. The evidence of the victim's intoxication, the theory at defense, well, I'm trying to remember. I'm trying to think about how this is relevant to any one of my arguments. I guess I raised an argument about the improper closing
You make
argument.
arguments about the
improper closing argument.
and also about the level of her intoxication.
Intoxication.
And I'm just wondering, why on earth is her intoxication?
well,
What does
the
it have to do with anything?
The defense presented evidence of her intoxication to support a theory that she was drinking shortly before the incident. This was relevant to, according to the defense counsel argued that this was relevant to support an inference that she had invited the assailant into her apartment for a social drink shortly before being killed. The defense theory, the government theory, of course, was that a stranger broke in and surprised her. The defense theory was that either whoever the assailant was, she knew him, supported by an inference that she had invited this person in to have a drink. That, for whatever it's worth,
Boy, that seems to me very far-fetched. Because she was drinking, she invited some guy in without any evidence of that. But
I don't
the reason it's
dis-
important is because if it's not relevant at all, it makes all your arguments about the alcohol level irrelevant.
I didn't make many arguments about that.
There are arguments in the briefs about
Well, the only argument I made about intoxication, correct me if I'm wrong, but I think the only argument I made about intoxication was that the prosecutor improperly represented the record, and the Commonwealth correctly pointed out that I was mistaken there, and I acknowledged the Commonwealth's statement. I specifically said that the prosecutor made an argument that that sometimes endogenous alcohol that can be created by the body's decomposition, can be as high as 0.3. And there was evidence in a voir dire from a chemist that he had seen that, but that evidence was not introduced. But in fact, a defense witness did testify on cross-examination that he had seen evidence of as high as 0.3 in the past. I agree that the Commonwealth is correct about that. I do not press the point. I don't think I relied on intoxication in any other way in the case.
Well, you said evidence of Ms. Andre's intoxication was also important because it undermined the prosecution theory that she was surprised by a stranger, and I couldn't follow that.
Okay, well, if Your Honor doesn't accept
But I
that,
understand what you're saying now.
I recognize the stretch of the inference, but I want to get back to this principal argument.
Mr. Wood,
After Frink and O'Brien.
Can I just ask
Sure.
you on that, and you'll have time. When Judge Moriarty decides that this evidence can be admitted, he recognizes that, that it might be able to slop over into propensity evidence, and he says that, he's going to give a very strong, the defendant's entitled to a very strong instruction that the evidence cannot be considered as evidence, that he's a bad person and so on and so forth. Because I haven't looked at the transcript, if the prosecutor used it for propensity evidence, which is your argument, and there was an objection, what did Judge Moriarty do?
He did nothing. Well, he gave the boilerplate instruction. He did not give any special instruction at all on this issue.
No, but at the time there was an objection.
Yes, and there was no action taken beyond this standard boilerplate instruction.
Did he sustain the objection?
No. The instruction, I believe the objection came at the end of the closing argument. It was not an interruption argument, interruption objection. I think it was at the end. I think he simply overruled it. I think he viewed it simply as more a continuing objection to the admission of the prior bad acts, which had been made all along, and now you're using the prior bad acts. I think his view was, I admitted the prior bad acts, I submit that they're relevant, and so the Commonwealth can use them. I think that was his, but he didn't articulate any of this. I mean, simply, objection, use the prior bad acts, overruled at the end of the argument.
Overruled?
Well, I mean, well, he took no, I mean, at the end of a closing argument, objection, Your Honor, duly noted. I don't think he said anything in particular, but he certainly didn't give any specific instruction beyond the boilerplate instructions. I know my time is up. Very brief.
Finish your argument on this.
Thank you. On the masturbation, first, so the Commonwealth, I have 3 points on masturbation. First, there's no evidence of a connection between masturbation and sexual frustration, much less sexual violence. The Commonwealth argues masturbation proves that he is sexually frustrated, which is relevant to the act of sexual violence we ultimately have here. I don't dispute it's an act of sexual violence. I dispute a causal connection between masturbation in your own apartment, looking out a window, and sexual violence as a result of breaking into somebody else's apartment and killing them. That's the causal connection I dispute. In fact, there's evidence in the record from the new trial motion. I actually contacted an expert on sexual violence, a criminologist who testified or who reviewed the evidence, the research, and concluded that there's no evidence of a connection between sexual frustration or masturbation, indecent exposures on the one hand, and sexual violence on the other hand. So to the extent that there's any evidence, it's negative. Now, secondly, to the extent that masturbation is some evidence of sexual frustration, it is clearly distinguishable from sexual frustration that would lead a person to seek out violent sexual encounters with women by breaking into their apartments and killing them. That is recognized by this court in Commonwealth v. Scott. I've cited that in my brief. And third, finally, again, we have the exact same pattern of a blatantly improper propensity argument. The same three-step argument. The Andres killer was clearly a sexual deviant. The masturbation shows that the defendant was a sexual deviant. Therefore, the defendant was the Andres killer. Blatantly a propensity argument, not used for the claim of sexual frustration, used as a propensity argument. And then finally, we have the Kelly assault. Very briefly, I argued that that Mr. Montez was not the Kelly assailant. But beyond that, I argued that the Kelly assault did not share a special mark or distinctiveness with the Andres assault. Again, the Andres assault, the Commonwealth, and this is an important point which I should have mentioned in the Frink and O'Brien burglaries, the prosecutor in his closing argument did not claim that in Andres the entry was by key. If Your Honor believes that there is some evidence of entry by a key in the Frink and O'Brien cases, which I dispute, the prosecutor said that in the Andres case, the method of entry in closing argument was by climbing up an outside porch because there was a handprint on the joist supporting the porch and coming in through a sliding glass door. The prosecutor made clear he was not relying on evidence of invasion by a key. In the Kelly case, by contrast, it's clear that the entry was by key. Miss Kelly was home. She testified she heard him coming in through the back door. Secondly, the weapon was different in the two cases. A knife in the Kelly case, a gun in the Andres case. Third, in one case you had a threat of rape. In the other case you had no evidence of rape. And finally, there was no evidence in the Kelly case of how this incident was going to be played out. There's clearly a very special mark of distinctiveness in the Andres case about how Miss Andres was found. There's no evidence that as to what was going to happen in the Kelly case. And it's crucially important. This court
there was no way for the Kelly case to play out because it was interrupted, wasn't it? Right?
Absolutely,
So
Your
we
Honor.
don't know what might have
Absolutely.
been the result.
And the Commonwealth made this exact same argument in another case before this court, Commonwealth v. Jackson. I cited to the case extensively in my reply brief. Essentially, the Commonwealth says we can all infer what was going to happen in the Kelly case.
Well, in the Kelly case, wasn't she told, I'm going to rape you and then I'm going to kill you?
Yes, but...
So at least we know that. We know what she was told by the assailant.
Yes, but I submit that a rape is not... Well, first of all, there was no rape, no evidence of rape in the Kelly case. It was clearly a sexualized killing. In the Andres case. It clearly was a sexualized killing. However, there was no evidence of rape in the Andres case. Here, he says, I'm going to rape you. So if we take him at his face value, that is actually contradictory to the special mark or distinctiveness of the Andres case. I know it's unappealing, but I also have to submit that that is crucial as a distinguishing characteristic of the Andres and the Kelly cases. And finally, there is no greater shared distinctiveness between the acts here and the acts in Brazgulis. In Brazgulis, this court held that all of these cases were common. The incidents were all involved characteristics common to assaults on women in public parks. You had a series of incidents of a man assaulting women in public parks, and the court says These are not distinctive. This is typical. Here you have at most assaults on women, sexual assaults on women in their apartments. I submit that is enough. That is not enough.
Mr. Wood,
Yes.
I heard the word finally.
Yes.
Just 2 sentences back. Thank you very much.
Thank you for your time.
Ms. Julian?
Good morning. May it please the Court, I'm Marcia Julian with the District Attorney's Office representing the Commonwealth today. First, I would like to address a few points that my brother made in conjunction with the first argument. And one is that he led off with a discussion of the triplet case, and I would just like to draw the Court's attention that that argument was not made in his brief, nor was the case cited. With regard to the admissibility of the other crimes evidence, in fact, I should qualify that remark. I did not check his reply brief, but in the main brief, that point was not made. The other crimes evidence, the context in which this all occurred is very important, and it wasn't discussed earlier. Judge Moriarty was the presiding judge at 2 trials.
By the way, you say that he didn't preside at the motion for new trial because he was dead, not because he had retired. Is that accurate?
Yes. This is Judge John Moriarty, who was the father of the current Judge Cornelius Moriarty on the Superior Court. Judge Moriarty was a judge of the Superior Court for many years and died more than several years ago. But he was the presiding judge of both trials in this case. The first set of indictments to go forward.
I'll just tell you that
Yes.
he did refer to triplet in his reply brief on 3 occasions.
I'm sorry, I didn't hear you, Your Honor.
The defense counsel did cite to triplet in his reply brief on 3 occasions.
Oh, it's in the reply brief, then I stand corrected. I did not see it in this main brief. I apologize.
That's okay.
With regard to the context, and I think this is very important as a backdrop to the judge's ruling on this issue, 3 months before the Andres case went to trial in January of 1994, in October of 1993, Judge Moriarty presided at the trial of the Kelly and Ramos indictments. Same defense counsel, same prosecutor, all the same parties. This issue was raised in the first case. In fact, the appeals court addressed it in its opinion, and that decision was upheld on further appellate review by this court on the evidence being offered for the purpose of identification. And this was also is very important, is this was an entirely circumstantial case. And Judge Moriarty made that point in his ruling that the issue at trial was the identification of the killer. So this was highly relevant evidence to the issue at trial.
Also very prejudicial.
Yes, Your Honor,
Extremely.
and oftentimes relevant evidence is prejudicial. It's inescapable. And in this case, however, it was properly admitted.
Did the defendant cross-examine Ms. Kelly effectively at the trial of her rape case? The defendant says he didn't.
At the trial, well, Your Honor, I would refer you to the appeals court's decision recounting, and my own brief, recounting, he had a different trial strategy in the first trial, and that was to undermine the credibility of the identification. And that, too, is important from a contextual standpoint because 3 months earlier he'd had a dry run, so to speak, and he'd had an opportunity to do just that. And he had an opportunity to see what type of a witness she was.
The defendant argues that he never argued in, the defendant states that he never argued in Kelly that the identification should be excluded, so that there was no argument as to the suggestive elements of the procedure. Now, is that
I respectfully
incorrect?
disagree with
Okay.
that. And I think you'll see in my brief where I cited to the motion in limine that defense counsel brought of voir dire was conducted, the judge ruled on the array, and the admitted the identification evidence.
Ms. Julian,
Yes, Your Honor.
I've read pieces, but not everything. So I've read Judge Moriarty's ruling. He doesn't seem to address the special mark or distinctiveness argument. I mean, he essentially, if you read his ruling, he's really saying it sort of backs in from the fact that things were found in the defendant's apartment.
Well, I think if you read the ruling in its entirety, he, of course, considers the appropriate case law on the special mark of distinctiveness. And he recounts the factors that I think Justice Ireland referred to earlier about the temporal and geographic proximity of the crimes. and the intrusions in multi-apartment buildings, the suspected use of a key in each incident, and in fact, he doesn't mention this, but I add the recovery of keys in 3 of the 4 incidents in the defendant's apartment.
House keys, recovery of house keys?
Well, all right, I'll jump to that part of the argument. But I just would like to, before I do that, bring to the court's attention this context, and I think it's extremely significant because these witnesses all testified in the first trial, and he heard the evidence concerning.
But that's another
That could be
trial.
helpful or hurtful.
Well, I would submit in this case it's helpful, and I think when you have an opportunity, of course, I've made the transcripts from the first trial are a part of the record in this case as well. And now I'm sorry, Justice Cowan, I've lost track of what you asked me. The house keys. You asked me about house keys. Yeah, I'll go through them one at a time. The first incident, of course, was the murder in January. In February, Eileen Frink's apartment was broken into. She returned home from a weekend away, used her key to unlock the front deadbolt, found the chain lock on, did not go around to her back door. I disagree with my brother on that point. She went to get her landlord or her superintendent, who got her into the apartment. The back door was deadbolted. I'm pretty sure they broke the chain lock. In fact, O'Brien broke the chain himself. When he
So
found
the back door was deadbolted. What about the front door? This is Frank.
Both front and back doors in both cases were deadbolted shut. When Frank went into her apartment, she noticed what was gone and her jewelry box upset. She noticed her bathroom window was open. The bathroom window did lead out onto a porch. Now, the key is important here because that porch was accessible by a locked gate on the first floor. So there was a suggestion that whoever got up to that porch to get in that window had access to that porch by virtue of a key. Now, no, the key wasn't recovered, but I don't think the recovery of the keys are significant here. I think it's the suspected use of the keys. It's a modus operandi.
Wait. How can we infer the person had a key just because he got in?
There was evidence at trial that that was the only way to get onto that porch. It was locked at the bottom. You couldn't get in otherwise.
But we don't know. I don't see the inference. The bathroom window was open, so that means somebody
It went out onto a porch because this was not on the ground level.
To get onto the porch, you had to go through a locked gate. You couldn't climb over a fence. How high was the fence?
Well, I don't know. There wasn't testimony, but the superintendent was brought in.
I mean,
who
I know
testified
locked
that
gates, and I see people climbing over the fences by them all the time.
Well, Your Honor, I think the jury went on a view in this case. I'm not sure if they
But
viewed
what I'm
this-
saying is I don't see an inference that he got in by using a key. Was the gate
There was direct
open?
testimony from the superintendent or landlord of the building that was the only way to get onto that porch, to get into that window. There's actual testimony, and I don't believe it was impeached. So there's evidence that the porch was accessible only by use of a key. And in both trials, and Judge
But
Moriarty...
can't someone also pick locks?
Well, Your Honor, I suppose anything is possible, but there's a signature here, and it's keys. I
think it may be, if we look at it carefully and say there's only one way to do it, which is keys.
Yes.
But at least as I listened to Mr. Wood's argument and read the briefs, the claim is no. There's an assumption that it's keys, but it isn't.
Well, I think it's more than an assumption. I think you have evidence with regard to the first robbery.
Was there evidence that her key to that porch, locked gate to the porch, was missing?
Well, she had gone away for the weekend and had her keys with her. So there's not evidence that her house keys were missing. Her car keys were stolen, and they were recovered in Kevin Montez's apartment.
Why did she
He
have
took
to?
keys from her apartment.
Why did she have to go to get the building manager to get in if she had keys to her
I
apartment?
can't explain how she reacted to finding. Maybe she was frightened by the fact that. I don't really think I should speculate, but that's what she did. The chain lock was on. I'm sure she knew. She testified she didn't leave it on, and that it was unusual. So she went to get some help. And
Chain lock on both doors, front and back?
I don't think the back door had a chain lock. I think both front doors in both cases had chain locks. But there's not testimony that either of them went to their back
So where was the
door.
evidence that the defendant had the key to that apartment?
Well, the evidence is that there's suspected use of a key to get into that apartment from the ground floor through the lock gate to get to that porch that led to that bathroom window.
How did they suspect that he got the key?
Well, it was the only way he could have gotten in. Besides, he
Didn't
took
lose,
her.
but I mean, she didn't lose her keys.
But Your Honor, in addition to that, there's a different.
Wait a minute. In addition to that, I didn't get to the part that you're adding on to.
I'm sorry.
If she didn't lose her keys, what was the other way he could have gotten keys to get in?
Well, that's not resolved. But he obviously had stolen keys. There was evidence that he had keys to a Domino's pizza parlor. He
I
had
understand
a
that.
superintendent's master.
He didn't steal
key.
them from her.
Well, he stole her car keys. They were in his apartment when the police searched it. He had taken her car keys. That was one of the things they recovered there. And now, with regard to the O'Brien case, when he came back, he found a small pane of glass, and I also respectfully disagree with my brother on this point. There was evidence that it was too small for a person to fit through. That was the testimony. And that door was dead-bolted from the
But
inside.
we don't know how large it was.
I'm not certain if there was testimony in inches.
But it could have been,
and
it was big enough to put a hand through and then
well,
undo the lock.
I think that's a fair inference. It was too small for a person to fit through.
Yeah, but it could
But-
be, 2 feet by 2 feet is different than 4. In any case.
Well, in any case, Your Honor, that's the evidence. This trial took place in 1993. This
Is the
many years-
identification, the Brisgoulas case, the identification aspect of prior bad acts, is the identification evidence in this case, does it relate to MO, the method of operation, or does it relate to the fact that there was stolen property in each of these apartments that was found in the defendant's apartment?
Well, I think nothing's a perfect fit because these cases are case by case, fact by fact. And this is a combination of several things. It's not a Brisgoulas case. It wasn't a series of assaults on women, this man interrupting joggers in various parks. It's a very different case, and I don't really see it as terribly applicable here. Rather, I would rely instead on cases like Leonard, Commonwealth versus Jackson, where the court laid emphasis on, in addition to the factual similarities in the crimes, but that they occurred 2 weeks apart and 3 blocks away from each other. So this is a combination of those factors that I think that is significantly corroborated by the fact that when they go into the defendant's apartment, they find Frink's property and her car keys. They find O'Brien's property. They find the...
Yeah, the only trouble with your argument that really is bothering me is that if someone lives in a high crime area, and we've certainly had opportunity to see what that is these days, and that means that they have proximity in time and place.
I'm sorry, I
If
don't
somebody
understand the
lives in
question.
a high crime area where there are a lot of break-ins or assaults or whatever you want,
Well, I don't think there's evidence in this case of that.
no, but we don't know. But you're trying to say that makes this distinctive. And I'm saying it doesn't make it distinctive
Well,
because
it's a factor the court has traditionally relied upon,
Well,
the
but just
temporal
because-
and geographic proximity of crimes.
Not
I
for-
mean, Brisgoulas, I believe, was 10 years, and I mean, they said the court said it's very difficult to discern a pattern over a period of that many years. This was January, February, March of 1993, literally on a corner in Springfield in a residential neighborhood. That's another point I wanted to make.
But there's a difference between, those cases list all about 6 or 7 different reasons for allowing prior bad acts. And oftentimes we see judges make findings of fact saying that, it's MO, it's identity, it's a pattern of conduct. Which is it?
This is identity.
This is identity. It's
This is
not, because
identity, and
I just
I-
heard you say pattern of conduct.
I'm sorry, I misspoke. These crimes were admitted for identification purposes.
So it's...
And so the case law concerning signature and mark are clearly applicable here, yes. I'm not trying to suggest that I'm straying outside of that area of the law. And as I said, and I was discussing the key issue seems to be the important one here today, and the second break-in, which occurred March 14th on Sumner Avenue as well. When he returned home, he found both doors deadbolted, and he testified that...
Who is this? Is this O'Brien?
This is O'Brien, yes. And that was the broken pane of glass, and that from his perspective, the only way to have gotten in would have been with the use of a key.
Well, was there any evidence of how close the broken pane of glass was to the doorknob and the lock, or whatever kind of lock it was?
No, but there were photographs that the jury saw.
So there is evidence?
Well, there is, yes, and I haven't looked at the photographs, but photographs were
That would have been
introduced on
helpful.
all of, so I can't
So
tell you specifically.
If there's evidence that the back door pane was broken, and the door pane, let's assume, was somewhat close to the doorknob and the deadbolt, if you said the back doors didn't have deadbolts in both cases.
No, they do have deadbolts in both cases.
Seem to have gone both ways, but okay, so
Yes.
the back doors do have
Yes, they do.
deadbolt, okay.
In other words, there are
So-
four
so if
doors
the-
involved. Everything was deadbolted.
Okay, so if the broken pane of glass is big enough for a hand to go through and is somewhat close, which it probably is, to the doorknob, then the assailant could have opened the deadbolt and turned the knob and gotten in.
Well, it was in a deadbolt operable by key.
So you had to have a key.
I think you're
Deadbolt-
thinking of a knob or something,
It's a
but this is
deadbolt that's only operable by key.
Yes, that
From
was
the inside?
from the inside.
You mean you have to take a key when you're inside to open your deadbolt to get out?
Well, this is what he testified to, and again, this was in 1993. I mean, I'm sure
Well,
that the nature of locks have changed.
That wasn't
over
a
the-
century ago.
No, but I mean, no, it wasn't a century ago. but
Deadbolts were
a lot of
opened by
things have
keys
changed
from
for
the
me since then.
inside. You couldn't open, you're saying that
His testimony was it was operable by a key and that's why, that's why he believed that someone had to use a key to get into his apartment through the back door.
Can I go back to the...
That was the state of the evidence. I'm sorry, I can't give you any more information.
Let me just go back to the Kelly property once more. She had her house key.
He did. She had her house key.
She had her house key. He had her car keys.
No, Kelly, he had her house keys. Kelly is the attempted rape.
Well, who's the one that
Frank,
lost her
Frank.
car keys?
Okay, well, the two break-ins.
No, just the name of the
Frank,
person.
Frank, I'm sorry.
Frank?
Frank,
Frank.
F-R-I-N-K,
Okay.
Eileen Frank.
Now, was there a separate key other than the house key that's used to gain access into that back stairwell that gets you up to the landing where the bathroom is? And was that key missing?
The testimony is what I've told Your Honor. There's
It's
nothing more
inconclusive,
that I
Okay.
can say on that subject. I'm sorry, but these witnesses testified. There was testimony introduced by the Commonwealth concerning these breaks. The judge heard it twice, and then he also held an evidentiary hearing, and he had a hearing on reconsideration.
I'd like to ask you about the masturbation before your time is up. You say in your brief on page 4, the masturbation incident was closely connected to the other crimes by the discovery in the defendant's apartment of evidence from the burglaries, the murder victim's TV set and articles of clothing and the knife used in the J.K. attack. How is the masturbation incident connected to the other crimes because of the discovery in his apartment of this other evidence?
Well, it may not be artfully phrased, but I think it certainly is corroborative of
what?
It was offered. Now, that evidence was offered for a different reason.
I know, but that's why I'm asking you why you say this in your summary of your evidence in your brief. I was reading right from your brief.
Well, I may have to look at it. I'm not sure in what context I said that.
It's on page 4 of your brief.
Page 4. Oh, that's in the summary of the argument?
Right, yes.
I'm sorry. I guess I would ask you to look at my argument. Maybe it doesn't accurately reflect my argument, but.
Okay, so it isn't connected through the evidence of the other crimes.
Well,
Well, I couldn't see how it was, and I'm giving you an opportunity to explain. Maybe you say it doesn't.
Well, I think what's important about that evidence is that it was offered to show that it was his plan to procure sexual encounters with his
Why
exclusively...
has masturbation got to do with that?
Well, Your Honor, I would refer you to the Scott and the Finney case. They're both very close to this. And this is inappropriate, persistent, sexually based conduct that this man engaged in against his
Inappropriate,
female...
persistent. What's persistent? They saw him masturbate once, I
No,
thought.
no.
No, there was
They saw him
testimony that
masturbate more than once?
he did it continually. He was
Okay.
asked over and over again to stop by her boyfriend, and when he did it that final time, they called the police, which of course led to them coming into the apartment and finding all of this property. I see that my time is up, and I feel that I didn't fully address most of my arguments, so I would have to rely on my brief.
Can I ask you one question, though?
Certainly.
Through all of this, it was hard for me to understand, leaving these 1, 2, 3, 4 other crimes aside, what was the evidence against the defendant,
Well,
other than the TV found in his apartment?
Well, in addition to the television set,
The
in his
keys.
apartment, there was a key to the front door to her building,
To Andres.
to Andre's building, to 16 Sumner Avenue. So again, that's another key. And there was a letter introduced that was misdelivered to, he lived at 106 Long Hill. It was misdelivered to 116 Long Hill. The police recovered the letter, and in it he's written a letter to his girlfriend after he's been arrested, and it's cryptic, and I've included it in my brief, but the gist of it is what people say about it, or what I said about it happening in the living room. It happened in the bedroom. Maybe I'm mixing a little Kelly in there. Joan Andres was killed in her bedroom, and Kelly was attacked in her living room. So it was a purely circumstantial case. There was no physical evidence in both the Kelly assault and in the Andres murder. Well, the Commonwealth theorized that he dressed the same way he did, and that was completely covered up with gloves. There was no hair evidence. She was badly decomposed, so they couldn't confirm whether or not she'd been assaulted, but there was testimony that it was a sex-related homicide. She was naked. Her clothing had been cut off of her. There was certainly a theme that comported with what he had told Kelly he was going to do to her, and that he wasn't afraid to do so because he'd done so before. I would ask the court to review my brief and the record and reaffirm the defendant's conviction. Thank you.
Thank you, Ms. Julian.